If you are charged with a felony charge in the state of Colorado, you most likely have heard the term preliminary hearing tossed around in court. A lot of people call it prelim for short. So what is a preliminary hearing? The best way to think about a preliminary hearing is basically it's a mini trial, but I want to dig in a little bit further. So a preliminary hearing is designed for higher level felony cases or cases that are putting a defendant more at risk. In other words, if someone is facing higher or extreme charges, or if they're in custody, if they're in jail and they're sitting there in jail on these charges. So preliminary hearings are for higher level felonies if you're out of custody, usually F4 and above, so class 4 felony and above. Or if you're in custody, you automatically qualify for a preliminary hearing so long as you're in custody. And what it is it's a requirement that the DA prove that they have probable cause to charge you for the offenses that they're bringing against you. In other words, when they have that complaint information, let's say you're charged with kidnapping. It's a very high, serious felony in the state of Colorado. So when you're charged with kidnapping, you have the right to a preliminary hearing. In other words, you have the right with your defense attorney to get the DA to prove that they have even probable cause to bring these charges. And the reason that it's only available to felonies is because you're facing a lot higher of a risk. You're facing exposure to a lot more prison time, and it's a much more serious charge. The state of Colorado is just not equipped to offer preliminary hearings on lower level offenses, but in these higher level offenses, it is worth the time and energy of the court to have these available. Now, in this preliminary hearing, the DA has to prove that they have probable cause for the charges. The rules are more relaxed in a preliminary hearing, though, than at a jury trial. So the DA does not have to prove beyond a reasonable doubt that you're guilty of them. They just have to prove that they have enough evidence and probable cause to charge you. They also don't have the same rules of evidence in a preliminary hearing that you do in a jury trial. In other words, you don't have to have a number of witnesses come in for a preliminary hearing, and people can bring in statements that are hearsay statements. Usually what happens at a preliminary hearing is the DA will call 1 or 2 law enforcement officers and get them to testify as to why they believe that they had probable cause to charge you. And like I said, the rules are much more relaxed in this because the only issue is whether there's probable cause, not whether you're guilty. And so a lot of the times they'll say, well, what did this person say? What made you make that decision? And it's a much faster process. Now, the DA only has to get into the issues involving the specific elements of the higher level charges. So let's say you're out of custody and you're charged with a class 4 felony, a class 3 felony, those higher level felonies, and then you have a class 6 felony. The DA only has to bring in enough evidence through their witnesses to prove that there's probable cause for the 2 higher level felonies. They do not have to get into the lower level felony because it doesn't qualify for a preliminary hearing. Another thing to keep in mind is a lot of the times, at least in the state of Colorado, preliminary hearing is used as a bargaining point for the district attorney and the defense attorney. So because preliminary hearing is essentially a mini trial, the DAs are motivated not to do it because it's causing more work for them to subpoena their law enforcement officers. So a lot of the times what the DAs will do is they will say, okay, I'm willing to negotiate with you and your defense attorney, but you have to waive your right to preliminary hearing. What that does is basically you're saying, okay, I am not going to make the district attorney say that there's probable cause for this arrest because I want to keep negotiating and see what we can work out. This happens quite often, and the reason for that is probable cause is a very low threshold. You can reach probable cause very easily. Even if it's a super, super crappy case, there's still going to be probable cause in most cases. So getting with your criminal defense attorney and making sure that you understand the difference between probable cause and actual guilt is essential. And then deciding whether or not you want to take the benefit of negotiating further versus pushing it to preliminary hearing, which usually then results in setting it for trial, is a trial tactic and a criminal defense tactic that you need to review with your criminal defense attorney. In a lot of cases, there's not really any harm to waiving a preliminary hearing if there's very solid probable cause. So for example, let's say you're on a DUI 4th offense and you hit somebody. So you've got a vehicular assault and a DUI. And you get a BAC back of 0.2, which is a very high BAC. In a preliminary hearing, it's not going to be difficult to prove probable cause that you were driving and that you had alcohol in your system. So in that case, a defense attorney may advise you, okay, look, we're not going to get anything out of this other than end up pushing it to trial, which we don't know if we want to do yet. Probable cause does exist here. Let's fight a different battle a different day. And they may advise you to waive that preliminary hearing. It can be very complex, it can be very nuanced, and so it's very important that you have a criminal defense expert with you, making sure that you're guided through this process and understand what's going on. But in essence, the best way to conceptualize a preliminary hearing is it's a mini trial on serious charges to show that the DA actually has a case against you that they can bring. Not that you're guilty, but that they have enough facts there to even bring it up.